Morning. Please be seated. We're here for oral argument on Guerriero versus Guerriero. It's our number CV-25-0189. Each side has 20 minutes, as you know, and you may keep whatever time you wish for rebuttal, but you need to keep your time yourself. So please proceed.
May it please the court. My name is Stanley David Murray, and I'm the attorney for the appellee, Anthony Guerriero, who was the petitioner in the trial court proceedings. I would like to reserve some of my time, if I may, for rebuttal. The issue before the court today is whether an out-of-state, in this case an out-of-country marriage, would be recognized as valid in Arizona, even though the license that was issued is not valid. And we have a statute that pertains to out-of-state marriages. That's ARS 25-211. Under Part A, Arizona will recognize the out-of-state marriage if it was valid through the procedures that it was contracted in that state or in that
Counsel,
country.
before we go any further, I do have a question. You stated that the license is not valid. What is the import of the fact that wife went back and tried to have the license recorded, and according to Durango, it is now recorded?
Well, the Superior Court didn't agree that that had any effect, and indeed, it's under litigation right now in Mexico. But the
So that's a
testimony-
disputed fact.
It's disputed as far as whether or not that was valid.
Okay.
Right, it is being contested. But there was testimony from Mr. Ontiveros, the attorney that we had testify about Mexico law, said that it wasn't valid because that reapplication wasn't made with my client being present. Under Mexico law, both parties have to be present to renew a license.
Is that a factual determination that has been made in this case, or his opinion on Mexican law and what the
That's-
outcome might be?
That's his opinion, and I guess the Superior Court adopted it.
But you just said that it's a fact that's still being litigated.
Yes, ma'am. But as far as the Superior Court's decision was made, that was of no significance to the judge.
Counsel, since we're bringing up the license here, if we go back to when the license was first issued, as I understand the record and the arguments between the parties, it's Mr. Guerriero's position that not all the documentation that would have been required for a valid license to be issued was provided. Was there sufficient information provided that if it had been provided here in Arizona, a valid license would have issued?
Arizona doesn't have the same requirements as Mexico does, Your Honor.
Okay, so if the parties had sought a license here in Arizona with the same amount of information that they had at that point in time, we would have issued a marriage license.
Yes.
Okay, thank you.
You know, what is undisputed, though, on this record is that the documents were not filed. And so the civil registrant who performed the service, I won't say annulled, but he canceled the marriage certificate that he issued because of lack of documentation.
And I have a question on that. Did he have the authority to cancel the marriage?
As an administrative physician, I believe he did, Your Honor, because he was the one that told the parties, get these documents to me within 60 days. Actually, his affidavit says 90 days. And he told them that if they don't, he's going to cancel the marriage. Nobody questioned that or challenged that. So
Well, I mean, but does he have the authority to do that?
my understanding is he did, since he advised the parties.
Is that authority an issue and dispute presently in those proceedings in Mexico?
No, ma'am. I think what the issue in Mexico is right now is whether that refiling that the wife did renders the marriage valid and whether it's retroactive. That's the issue that's before the Mexico court. It's undisputed on this record that the initial license wasn't valid because we didn't get the proper documentation filed on time.
Under 25-112A, the law provides that marriage is valid by the laws of the place where contracted are valid in this state with an exception that doesn't apply here. If the license, the Mexican license, is determined invalid, do we conduct some sort of record review to determine whether it would have been valid here? Or does the law require validity in the place where it was contracted and we just simply accept that as a dispositive fact?
Well, we would have the burden of proof to show if we're arguing that it's invalid, why it's invalid. And so the court would either accept that testimony or not accept it.
But
Is that your question?
if the testimony establishes as a matter of fact that the license is not valid, in this case in Mexico, in the foreign jurisdiction, do we then conduct an independent review, or does a trial court, to determine whether that license would have been valid if the information presented there had been presented here? Justice Montgomery asked you the same question, and I'm just sort of following up on that.
Right. If it was a marriage entered in Arizona, yes, it would be valid. But the problem is the marriage was entered in Mexico here. And so 25-112 comes into play. Under Part A, the Superior Court said, no, the marriage is invalid because you didn't do the proper licensing procedures. Under Part B, the Court of Appeals said, yes, it is valid because you had a solemnization and you intended to move to Arizona.
You think that what they're getting to, because I had the same kind of question, is just looking at the statute, trying to figure out how it works. So the first one doesn't apply, A, because it's not a valid marriage in Mexico. That's not an issue here. So B, solemnization, all right, if it has the same legal consequences and effect as if solemnized in this state, assuming yes, it does. And it gets to then what? Do we end there? You still have to have a valid license under Mexican law? Or do we look at some type of, well, it would have been valid in Arizona. All you need to do is get the license issued. You don't need to file it. By analogy, in Mexico, they got the certificate issued. They just didn't file it. But Mexico requires it to be filed. So we're trying to see, I think, what's the statute say of what should we be looking at? Do we need to, what do we do with the license?
To have a marriage in license, or excuse me, a marriage in Arizona, you have to have a license and solemnization. So according to the Donlin versus McGurn case, we're going to treat 25-112B as if the marriage occurred in Arizona. So you have to have not just the solemnization, you have to have a license. And that's under ARS 25 dash, got it handy here, 25-125, that says a marriage license is required plus solemnization. And then you go to 25-128 that says a person who does a solemnization cannot do so unless there's a license, a proper license has been presented. So if that marriage license was valid in Mexico, then yes, I think 25-211B would be met. But since it's not valid, you got to look to the Arizona law, because the Donlin case talks about how we have to have both the license and the solemnization.
If it's not valid in Mexico, what in the statutes require us to look at Arizona law to see if it has an equivalency? I see the equivalency with the solemnization, but I don't see anything saying you look at an equivalency for licensing requirement.
We look to the solemnization, whether it could have occurred or not without a license, is my interpretation of 211B. Because Arizona law says you can't just have a solemnization. That's the Moran case. So if we're going to treat this licensing requirement in order to have a solemnization, 211B doesn't say that you have a valid marriage simply because of solemnization. You have to have that license in order to have the solemnization.
Counsel, let me ask you a question follow up on Moran, though, because that was a marriage that was purportedly contracted here within Arizona.
That's correct.
Which kind of gets back around to, I think, the point that we're revolving around. As I read the cases, the reference to the restatement 283, the purpose statement for this part of our statutes at 25-103, and how other jurisdictions have treated which law to apply, the law of the place of contract or the law of the place of domicile. The point that I get to, so I'd be interested in your point of view on this, is that since certainly the parties here intended to return to Arizona, did return to Arizona, or domiciled in Arizona, we have an interest then in fulfilling the purpose of our statutes regarding marital and domestic relations. And the role the license would play would be simply to, in addition to looking at 25-112B, we would also go ahead and look at the license as well to see, well, if that had been done here, would it be valid here, given our interest in wanting to sustain marital and domestic relations. If I do that, from our conversation so far this morning, it seems that we would be well within the purpose of the statute, the relevant case law, and this area of law to say, well, wasn't valid in Mexico, but we can recognize it here.
I agree with you that Arizona having the more significant relationship to the parties, that Arizona law would apply and that Arizona would want to keep this marriage in place. But we know from the Donlin versus McGurn case, in fact, if I could recite to the court, in the footnote 8, that again talks about this license having to be valid.
Right, and that's a Court of Appeals case we never had the chance to review.
Right.
So I look at their reasoning there, and I'm not so sure they got it right. So help me see where they got it right.
Because of the Moran case, when you read that in conjunction with Donlin, you have to have a license. You can't just have a solemnization, and that's what the Court of Appeals is saying in this Guerriero decision. All you need is a solemnization and intent to reside in Arizona.
And I would agree with you, which is why I think we keep talking about the license.
Right.
Because I think
That's our
that
focus.
license may have a dispositive role in this.
Yeah, if they had applied in Arizona for a license, I admit it would have been valid. But we got to look to the law of Mexico, because that's the only license we're dealing with, and that
Now-
license was inadequate.
On that point, so can we look at this? The license was issued, and they held the ceremony, and it was signed by the bride and groom, by, I believe, 4 witnesses.
2 or 4, I can't remember.
Is there a difference between the license itself and the marriage potentially being invalid because there wasn't this other requirement met separate from the license? Because the license was actually issued and all of the information that needed to be placed in it was.
Well, the license, I guess, since we're talking about contracts, I kind of put it into a condition subsequent issue where, yeah, we're going to give you this license, but if you don't give us the documents, we're going to rescind your marriage license.
So it was a conditional license?
Well, from what I understand, Mr. Morga Monterez, the civil registrant, went ahead with the ceremony, and we're not complaining about the ceremony. We agree it was solemnized. But he put that condition on there, and he said, if you guys don't come back with these documents, I'm going to cancel the license.
Now, I have one last question on this point.
Go ahead.
So we review factual determinations for abuse of discretion, but we review matters of law de novo. How does that apply to Mexico law? Do we accept as a factual finding what Mexican law is, or do we need to look at the law ourselves?
You're free to look at the law yourselves. It's a de novo review when it comes to foreign law.
So it sounds like you were reading section 112B to require a valid license, which in my view would make it entirely redundant of 112A. How would, in your reading, 112B have any independent salience?
112A, you would have a license and you have a proper ceremony. 112B, you don't have a license, but you have a proper ceremony. So if you have a proper license, 112B would be met because you've had a proper license and you had a proper ceremony.
Well, 112A would be met, right?
But under 112B, if you had the proper license but you didn't have a proper ceremony, as what happened in Donlin, you didn't have the same, the person who solemnized didn't sign the certificate. Because of that technicality, that's when 112B comes into play.
Is it a mistake to view 25-112 as an independent statutory mechanism by which a foreign marriage becomes valid in Arizona? Isn't 25-112 just the explanation about how parties who are married in a foreign jurisdiction meet the fundamental requirements of 25-111? Isn't that essentially what this is? One of the requirements is that you have a valid license in Arizona under 111. 25A says if your marriage license is valid where it was contracted, it's valid here. The next requirement, of course, is that it be solemnized. 112B says that if it's solemnized in another state or country, it'll be recognized as solemnized here. And in fact, 111 says even if there was a technical flaw in the solemnization, but at least one party believed in good faith that it was legitimate, it's legitimate. So we're not going to determine invalid a marriage on a technicality about how the ceremony was constructed.
Correct.
But isn't it a mistake to read B as an independent mechanism to recognize marriage altogether that's a foreign marriage?
Right. Part B says, well, it presumes that you have a valid license because you can't have a solemnization without a license.
And 112 is just the mechanism through which, statutory mechanism through which the requirements of 111 are effectuated with a foreign marriage, correct?
Right. So long as the ceremony might have a glitch.
So
it-
then why does section 25-111 B provide a marriage contracted within this state. This marriage was not contracted within this state, was it?
No, sir.
Pardon me?
No, it wasn't.
So I don't see how 111 applies in this context.
111 deals with a marriage in Arizona. 112B deals with a marriage out of state. So when you separate those statutes out, you look through 112 because we have a marriage that was made in Mexico. The ceremony was
Okay,
fine.
this sounds like your answer to Justice Lopez and your answer to yours truly are different answers.
I see. How can I explain it? If you have a license application in Mexico, you got to do so many things. In Arizona, you don't. I agree. In Arizona, this probably would have been a valid marriage, but it wasn't. It was in Mexico. And the only thing that worked in Mexico was the solemnization. So aside from 111, we're looking at 112B because it's an out-of-state marriage. It had the solemnization. We're not complaining about that, but it didn't have a license. And so under the McGurn case, you have to have a license plus a solemnization. Under Moran, you have to have a solemnization and a license. So I keep coming back to that test, whether there was a license or not. Under 112B, that's the limiting factor, if you will.
Counsel, what is the best authority that you have under Mexican law for the fact that at the time the license was issued and signed by the parties, it was not valid? That's the first part. And second, the best Mexican authority you have for the fact that the person who purportedly voided the marriage had the authority to do that.
As far as your latter issue goes, we don't have any proof of that. But as far as the documentation goes, there were numerous Mexican statutes cited in the trial court talking about the documentation that's required: a medical record, birth certificate translated into Spanish, a listing of your properties, et cetera, et cetera. And that's all based on the testimony of Mr. Ontiveros. So I guess it's kind of a fact issue, but at the same time, Mr. Ontiveros was advising the trial court on Mexican law on that issue. But as far as the commissioner or the registrant having the authority to cancel, I don't think there's any authority in the record on that. But again, this court's free to make a de novo review on that issue.
Aside from issues with Mexican law, as I understand the record, ultimately, the marriage itself may not necessarily have been void, but was voidable. If that's true, and I'll ask you for your view on that. But if that's true, and we do consider restatement second in section 283, what I take to be a principle as discussed therein is that where the parties are residing within the state of domicile, we would apply our law because we'd want to meet their expectations, which I think are also set forth in 25-103, and the recognition that if the marriage had taken place in Arizona, it would be valid. Why wouldn't we treat it as valid? I know I gave you several premises there, and you may disagree with the very first one, but that's I see those different facts kind of lining up that would allow us, under the rationale that I just gave you, to find that, well, under our law, it would be valid, and so in this particular instance.
And again, if it was an Arizona application for the license, I would agree, but it was a Mexico application, and so the Mexico law would apply.
Well, and I understand your point on that because it's sort of a cornerstone of your argument, so I get it. But again, if we're applying our law and we wanted to meet the purposes of our statutes and the parties are living here, why wouldn't we look then, not just to the fact that the solemnization that occurred in Mexico would be valid here, the statute tells us that, but why wouldn't we also, given the interest of the parties and the interest of Arizona, look at the fact that the license as well, had it been issued here, that the parties would have been able to receive a valid marriage license here in addition?
Because that's not what happened. I don't mean to be smug, but it's just, it was a marriage in Mexico. And so under 112B, you have to look at the solemnization. Solemnization requires a license. We go back to Mexico to see if that license was valid, and it wasn't. I'm out of time.
Thank you,
Thank
Mr.
you,
Murray.
Your Honor.
Okay, Mr. Martineau.
Good morning, Justices. May it please the court, my name is Austin Martineau, and I am here representing Gloria Guerriero. Now, counsel has just made a concession here, and that is that he says that if this marriage had been performed in Arizona, it would have been valid. And that's what the statute requires. If parties are living in a different state, in a different country, and they intend to live in Arizona after they get married, if they perform a marriage there, and if it would have been valid in Arizona, then it is valid in Arizona.
What about the language of 25-112A? It says marriage is valid by the laws of the place where contracted are valid in this state. It doesn't say marriages that, if subjected to the requirements of a marriage license issued in Arizona, are valid in this state. It says marriage valid by the laws of the place where contracted, here Mexico, are valid, then it's valid in this state. How does the test that you just articulated conform with this statute? And if it doesn't, where in the law does it say that if a marriage, a foreign marriage, which is governed by 25-112 A in particular here, if it doesn't meet the requirements of that statute, then we conduct a separate inquiry to determine whether the information provided in that foreign jurisdiction conforms with Arizona's law?
All right, that would be subsection B. So it's separate and independent from subsection A. There's two separate avenues by which a foreign marriage would be valid here. One is if that foreign marriage was valid in that jurisdiction, subsection A. And the other, under subsection B, is if the parties intend to reside in Arizona. And if they do, then their marriage shall have the same legal consequences and effect as if solemnized in this state.
So it says under B that a marriage solemnized in another state, the solemnization shall have the same legal consequence and effect as if solemnized in the state. How do you read that creates a valid marriage in and of itself? That's not what it says. It just says that solemnization would be valid. Arizona law requires a contract and solemnization, and then solemnization within the expiration of the certificate or the license. So how does that fit with Arizona's fundamental requirements for a marriage license?
I'm sorry, Your Honor, I disagree with the characterization that the solemnization has the same legal consequences. The marriages will have the same legal consequences as if solemnized in this state. So if you look at the structure of the sentence, it says marriages solemnized in another state, et cetera, shall have the same legal consequences as if solemnized here. It's not talking about the solemnization specifically, it's talking about the marriage that has the same
And
legal
why would Arizona disavow a fundamental requirement that anyone, the requirement of a license? Why would we disavow that for foreign marriages?
The Arizona law does not disallow the requirement of a license. There was a license obtained here, and that was solemnized, and that's why it's valid. In this case, the parties did go to the proper authorities. The authorities gave them a license. They signed it. They certified at the bottom, this marriage is valid and binding for all legal purposes. There are no impediments to this marriage. That is a license. That is a certificate that was signed to witness. Arizona is not disregarding that requirement. It has been fully met here.
And so I take it under your interpretation of 25-112A that a foreign marriage is valid if it's not solemnized under 112A?
I'm sorry, say that again?
Under 25-112A, which reads, marriage is valid by the laws of the place where contracted are valid in this state.
Right.
Is it your position that a foreign marriage under 112A is valid without solemnization?
It can be. Common law marriages don't have solemnization. And that's why there's, by the way, two different terms, right? Subsection A talks about contracted, subsection B talks about solemnization. Arizona doesn't recognize common law marriages within Arizona, but a common law marriage can be performed outside of Arizona. And in that case, if it's valid there, then it would also be valid in Arizona. So those two terms, contracted and solemnized refer to marriages, but contracted marriages is just a broader term than a solemnized marriage.
Counsel, have we put the cart before the horse here? I mean, if there's still a determination to be made in Mexico about whether this marriage is valid and whether, and the effect of the 2023 registration and whether it retroactively validates the marriage or whether there was authority to void the marriage, all of these questions. If there's an ultimate determination that the marriage was valid back to the date that they were originally married, what effect would that have here? Should we have stayed these proceedings until that determination is made?
You don't need to stay the proceedings until that, because this subsection B, 25-112 subsection B, basically provides that regardless of whether it's valid. So that's true. It may have been valid under Mexico law. It may have been validated in 2023 when the documents were filed again, or in 2000 when the marriage took place. That's all very true, but regardless of whether it is true or not, it's still valid under the laws of the state of Arizona, so we don't need to go into that analysis.
So if we disagree with you on that point, though, 25-112A says marriage is valid by the laws of the place where contracted are valid in this state. So if we still need to, going back to Justice Cruz's point, if there's still proceedings in Mexico determining the validity under Mexican law, should we, if we disagree with you on 112B, if we're looking at 112A, do we, what do we do with that? There's still the validity under Mexican law that's still being litigated in Mexico.
Right. I don't think that we have to wait for them. That is a possibility to wait for a determination of what a Mexican court would say, but the Arizona courts, to my knowledge, do not need to do that. And of course, this was fully briefed at the Court of Appeals, but under Mexico law, the marriage is absolutely valid. Mexico law has provisions, specific provisions about when a marriage can be annulled. Unlike Arizona, doesn't have a whole lot of law on that. In Durango, Mexico is very, very specific, and it says, marriages are presumed to be valid. And if there's a defect and the parties are living together as a married couple, if they possess the marital entity, that's the phrase that it uses, then they cannot be annulled. The marriage is still valid.
Well, what do we do with the factual determination of the trial court that it was invalid according to counsel for husband?
I disagree that that's a factual determination. Yes, the officiant, Mr. Morin, he said he canceled the marriage, but you can't just determine that it's canceled by not filing it. That doesn't make any sense. There's no provision in Durango law that allows for that. There's an annulment process, and there was no annulment process that was followed here. So if they were married in Mexico, which they were, then that marriage is still valid and can't just be canceled because somebody said it was canceled.
So I think that Justice King's question was, assume that the court disagrees that Section 112B covers this, that we disagree with the Court of Appeals conclusion on that. That doesn't necessarily end the matter.
True. It is not necessarily end the matter, and in that case, then the court, this court or the Court of Appeals would need to look at Durango law and determine if this marriage is valid under Durango law. And the Durango Code is, like I said, much more detailed than Arizona on these matters. So it's actually clearer that the marriage is absolutely valid under Durango law as well.
And you agree, though, that but for the solemnization issue, which here was solemnized anyway, so it's kind of back to Justice Cruz's point, cart before the horse a little bit. We're focusing on solemnization, but there's no doubt, correct, that the marriage was validly solemnized under even Mexican law.
Correct. There's no doubt on that.
It's just this is really a license issue, but you agree that it has to be a valid license under Mexican law.
It has to be a valid license, yes. And counsel talked about, he said several times that this was not a valid license. That's the crux of his argument. A valid license is one that's issued by the proper authority. There is nothing in Mexico law, in Durango law that is, or Arizona law, that says that a license is only valid if every single step of the application has been fully met and fulfilled to a T.
Well, but I want to press back a little bit on that because there are specifics that clerks of the court are required to follow in order to issue a marriage license. Obviously, much more abbreviated than what's required under Mexican law. But you could have a clerk who might issue an invalid license that could raise an issue later on. So I guess I would caution trying to equate the two circumstances here in Arizona, here in Mexico, the same way.
You say that a clerk could issue an invalid license. Under what circumstance? If you're talking about fraud, forgery, something like that, then I would agree that that would be invalid. But for minor procedural defects, if a party fails to, for example, provide their social security number, if they don't give their address or their age, if the application is missing the statutory notice about data retention and privacy, that does not invalidate the marriage license.
Well, I would push back just on one thing too, and again, trying to keep this clear between what was required in Mexico and what was required here. I think if someone didn't provide their age and they were underage, that could be a capacity issue. But I take your point that otherwise, if it's on its face, the marriage license has the required information and it's issued, it's presumptively a valid marriage license.
Yes. And in the age question, if they're underage, that's the issue. It's not whether they provided the age or not.
So if you're, I just want to make sure that I'm clear on that, where I left off that you said that it's a valid license even under Mexican law. Ask us to look at that. If it's a valid license under Mexican law and it's there's no solemnization issue, why are we looking at 112B at all? Why isn't this a 112A scenario?
Well, we argued both at the Court of Appeals, and they ruled only on 112B. And
Okay.
so that's why.
Would your position be that we really should be looking at 112A?
At the Court of Appeals, that was our primary argument. Like I said, it was more clear because the code is so detailed. But I mean, either way is fine.
Okay.
Either way works for us.
But the thrust of the Court of Appeals opinion was that you don't need to consider 112A
Correct.
if you have solemnization under B. And I agree. It doesn't seem that anyone is disputing that this was validly solemnized. So that's required. The question for us is whether that's enough to independently establish a valid marriage in Arizona.
Right.
And the Court of Appeals didn't address A because they determined that satisfaction of B created the marriage.
Right. And that is permissible for them to do. You could look at either one. Yes.
Let me walk through, if I can, just one way to read the statute, and I wanted to get your thoughts on this, but the two statutes we're looking at. 25-111B says that a marriage contracted within this state is not valid unless you have a license issued as provided in this title, and the marriage is solemnized, and it has to be solemnized before the expiration of the marriage license. In the beginning of that, the subsection B says a marriage contracted within this state. Is it possible then that 112B was trying to articulate the language in there that you can have a situation where a license is issued by a county clerk here in Arizona, and 112B just makes clear, hey, you can go out of state or outside of Arizona to have your ceremony performed, your solemnization performed, and that will be a valid marriage contracted within this state. Is that a possible reading of those two statutory provisions?
So are you asking if subsection B refers to a marriage license issued by Arizona exclusively?
Well, 112B doesn't talk about the license. It
Right.
talks about solemnization. So, yeah, my question is really, does 112B, is it trying to articulate that, was the legislature trying to articulate that you can certainly have situations where, my husband and I go, we get our marriage license, it's issued here in Arizona, and we can go to Utah and have our ceremony performed there, solemnized there, and that will be a marriage contracted within this state under 111B. Because we have to give independent reading to 112B, of course, as separate from 112A. So I'm just trying to envision what was the legislature trying to intend by adding 112B, and is that a possible reading to read 111 and 112B, harmoniously?
Mm-hmm. It could be, but I think the intent of 112B is to just make sure that Arizona broadly recognizes marriages. If someone's going to come live in Arizona, even if their marriage had some defects under foreign law, it's going to be valid in Arizona. Maybe they had an Arizona license, maybe they had a license under that foreign state or country, but it'll still be valid under Arizona law.
To share one more thought on 112B then, could that reference to marriages solemnized in another state or country to be valid here also refer to the fact that 25-124 sets out who can solemnize a marriage in Arizona? And by the wording of 112B, then we would recognize a solemnization ceremony that was performed by someone who isn't within that list.
Right.
Do you see that as a corollary to it as well?
Yes, it is. It's just any defect, even if there's a defect in the solemnization, if someone didn't have actual authority to solemnize it in that other state or country, it would be valid in Arizona. Any other defects, as long as it would be valid in Arizona, Arizona will recognize it. Because Arizona has a policy of broadly recognizing marital rights, marital responsibilities, of not allowing people to simply get out of marital rights or get out of their responsibilities that they've agreed to and lived with for 2 decades, simply because of a technicality. Allowing people to do that is absolutely contrary to Arizona policy. And I'd also just like to reiterate that's what's happening here, in that Mr. Guerriero is lived together with Mrs. Guerriero as a married couple for 2 decades, and then he changed his mind and said, actually, we're never married, and that is unreasonable behavior, and his position is unreasonable for that very reason alone, and that's why attorney fees are going to be appropriate in this case.
Before you go, counsel, any idea on when the Durango court is going to resolve the dispute there?
I don't know. No, I haven't heard any updates on that. Right. Does the court have any other questions? All right.
No, thank you.
Thank you.
Okay, thank both counsel for their arguments today and their briefing. We'll take the matter under advisement and issue a ruling in due course. We will recess briefly to give the change.